Let me allow the legal team to give an input on our legal process.
Thank you very much, Comrade Muzi and Comrade Kabula. Unfortunately, mine is a legal one. It's not as revolutionary as Comrade Kabula. I've been asked by the President to just give a brief outline, because we've had so many cases, there's been a multiplicity of cases in such a short space of time that some people are confused as to where we are, which cases are still happening, and so on. And I was therefore asked to give some perspective and context. And as I say, my part will be quite short before I hand over to the political people. I'm just a lawyer. I don't know anything about politics. Yes. Now, and on a serious note, I've been given permission by the Pan-African Bar Association of South Africa that I'm a part of, as previously, to participate only in my professional capacity. So if you want to hear my political views, and I do have plenty of them sometimes, you'll have to go call me some other time. So the MK Party has been involved in what I call an unprecedented 11 cases in the space of about 3 months. I don't think there's any organization that has ever been to court so many times in such a short of space of time. In short, as you might know, from the 19th of March we were in Bloemfontein in the Electoral Court, where we had been taken by the ANC to deregister the party. They failed. On the 27th of March, the ANC also took us to the Durban High Court to fight over the logo and the trademark. They failed. On the 9th of April, the IEC took us to the Electoral Court in the Electoral Court, which was sitting in Johannesburg. And that was because the Electoral Court had taken a decision, as you might remember, to exclude the former president, and we had appealed against that decision. The Electoral Court found in favor of Mkhonto weSizwe and former President Zuma, and then they appealed to the Constitutional Court, where we brought a case for the recusal of the judges there, which they dismissed. And then on the same date, the 10th of May, there was the IEC appeal, which was upheld. Then a few days after that, there was a case in the Electoral Court where the IEC sought to remove Mr. Visvin Reddy and Bongosi Kanyile from the list on the basis that they had made certain statements. Then thereafter, of course, there were the two cases, one in the Electoral Court and the other one in the Western Cape High Court, brought by Mr. Jabulani Khumalo, who went to the Electoral Court and basically brought the same case in the Western Cape High Court, both of which were unsuccessful. Then in June, we we took the matter of, that was referred to by Comrade Tlamulo, which was the matter of the irregularities in the electoral results, as well as the composition of the National Assembly, to the Constitutional Court, which last week was dismissed on the basis that the court had no jurisdiction and it was not urgent, but the court then went on to deal with the merits. And currently there is an electoral court matter that Comrade Tlamulo referred to, and then also there's the electoral court case of the ATM in which the MK party is cited. So that is those are the 11 different cases. The second point I wanted to make is that Umkhonto weSizwe has done so well in that it was successful. It had a 100% success rate in all those cases, except those that were in the Constitutional Court, which dismissed both of Umkhonto weSizwe's applications, as well as, I suppose, the recusal application. The third point that I want to make, which is my final point, is that we, as the legal team, we are awaiting the judgment in the Bongosi Kanyile Visvin matter from the Electoral Court. We are also awaiting hearing dates in the new application, and in the two applications that were launched this weekend, one by Umkhonto weSizwe, the other one by the ATM. And as far as the Constitutional Court cases, and the President asked me to emphasize this, we have been asked as the legal team to look at ways to pursue those matters further, both locally and, if need be, internationally. The legal team will give a comprehensive advice to the clients, and the matters that are involved in that legal advice of the pursuance of these matters, both locally or internationally, pertain to two important matters. One of them is the setting aside of the election as a whole, and which, if successful, will therefore be followed by a re-election within 90 days. The second matter pertains to the removal from the list or from the membership of the National Assembly of former President Zuma, which we believe that was not done in accordance with international norms, particularly because in that particular case, as you know, those who followed it, the Constitutional Court made findings, including one of the findings was that remission of sentence does not reduce a sentence, and that the IEC is entitled to administer the membership of the National Assembly. And it is a strong feeling of the clients that both of those matters, or those kinds of findings, are in violation not only of our Constitution, but also of international human rights instruments. And therefore, thank you. And therefore, those are the matters that will be pursued further. So, if the media has been writing all sorts of things about these matters, some of them completely off the mark. So we just thought we should make those remarks. For example, the issue that was raised by Comrade Tlamulo about the matter that was raised in the Constitutional Court. Even today in the Sunday Times, there's a long article, I think by Frenny Rapkin, about how there was no evidence and this and the other. And this has been clarified 100 times, that case was not about the evidence. That case was about the premature declaration of the results by the IEC, number one. And secondly, it was also about the quorum, the issue of the composition of the National Assembly. And I just want, before I hand back, want to say that the problem, I think, sometimes is that the people who comment on these things are just lazy to read. And if one person makes a mistake in the media, then like sheep, everyone follows that mistake. And then it's just perpetuated. All these people had access to these papers, and I just want to read one paragraph, which makes it clear that they are all off a wrong tangent when they say, but where was the evidence and all that? This is what was said in those papers, very simply, at paragraph 15. Before dealing with the issue of jurisdiction, and in order to save unnecessary debate, which obviously we failed, it will be crucial to state upfront what this application is not about. Right? What the application is not about. And the word not is underlined. I say this application is not about reviewing or appealing the IEC's dismissals of the objections of vote rigging, incompetence and the like, or any cause of action which falls under Section 20 of the Electoral Commissions Act of 1996. The group of parties aggrieved by those decisions who are here have reportedly taken or intend to take whatever legal steps are open to them in that regard. The applicant also intends to present whatever new evidence it has gathered in that respect to the IEC in the form of objections. Those issues are referred to here in merely for historical context. What this application is about is the separate issues of declaring, in terms of Section 172 of the Constitution, certain conduct of the IEC, that is the rushed declaration of results, to be unconstitutional, setting such conduct aside as just and equitable remedies, and giving a proper constitutional interpretation to Section 46 of the Constitution. That's the one that deals with the composition. So anybody who wants to be asking all this, why was there no evidence in the application and all that, must just read paragraph 15 of the application. Thank you very much.